Hi, this is Josh Blackman, and this is the ninth match in the semifinal round of the 2025 Harlan Institute Virtual Supreme Court competition. We are moving the case of Free Speech Coalition versus Paxton. And for our first case today, we have a petitioner team from Creekview, Texas. Han Lee and Kaylee Ricker with petitioners. We do not have a respondent from this round, but they will get all their time. So we'll start with 10 minutes and then 5 more minutes, and then we will wrap up. So, counselor, you may begin whenever you're ready.
Will you be sharing the time with us?
I will be sharing the time, and you'll see it right over there.
Okay. Good afternoon, Chief Justice, Associate Justice, and may it please the court. My name is Kaylee Ricker, and along with my co-counsel, Han Lee, we represent the petitioner Free Speech Coalition in today's case. The question before the court is whether Texas House Bill 1181 should be reviewed under rational basis or strict scrutiny. It is our contention that Texas House Bill 1181, or HB 1181, imposes a content-based restriction on speech and must therefore be subjected to strict scrutiny, which is the most rigorous standard of constitutional review. Texas House Bill 1181 imposes a content-based restriction on speech by targeting explicit material based on its message, necessitating the application of strict scrutiny. Laws involving content-based restrictions also are subjected to the most rigorous standard of review under the First Amendment. HB 1181 in particular discriminates on the basis of the content contained within the speech. The court has previously established in precedents like Ashcroft and Brown v. RAV that content-based restrictions are to be reviewed through a strict scrutiny analysis in finding its constitutionality. Strict scrutiny observes two requirements. One, the law must demonstrate a compelling governmental interest, and two, it must be the least restrictive means. If the law is not narrowly tailored, then it may not pass the standard of strict scrutiny, despite demonstrating a compelling governmental interest. Policies included within HB 1181 constitute a content-based restriction, thus requiring constitutional review under strict scrutiny. In meeting the two requirements of the highest standard of review, HB 1181 does identify a compelling governmental interest in ensuring the protection of minors from explicit content on the internet. However, this comes at a cost of burdening the privacy rights of adult individuals by requiring digital identification for the purposes of age verification.
If I could just jump in, please. So let's just go over this again. Why do you think strict scrutiny applies here? Just explain that to me, please.
Yes, Your Honor, strict scrutiny applies in today's case because the House Bill 1181 entails a content-based restriction, and as consistent with past precedents, content-based restrictions are subjected to be reviewed under strict scrutiny under the First Amendment because it is targeting protected speech.
Oh, but is this a content-based restriction or is this an age-based restriction? Just help me out with that, please.
Your Honor, it's a little bit of both in today's case.
Okay.
We can see that yes, there is a age-based restriction in regards to protecting minors. However, within the fact that it is a content-based restriction that is protecting all of what HB 1181 calls sexual material, this is also infringing on adults' rights in today's case, since they are being limited to the access of pornography in today's case.
I appreciate your honesty. So it's a little bit of A, a little bit of B, a little bit of both. But isn't the usual rule that when it's both content and something less, that you choose the higher standard, that you don't, so you level up, you don't level down? In other words, if you can argue it might be content based, it might be age based, we choose the more serious one. We choose the content based, and we really need strict scrutiny.
Yes, Your Honor. This petitioner is contending that we should use strict scrutiny and classify it as a content-based restriction in today's case. Because HB 1181 is explicitly regulating internet platforms and their distribution of material that contains, quote, sexual material harmful to minors, targeting speech based on its content rather than its conduct. By requiring age verification measures and mandatory warning on landing pages, the law singles out specific forms of expression based solely on their message and themes.
Oh, let me just interrupt you. It's not, I mean, yes, they are singling out the messages, but what the singling out is pornography. And the Supreme Court has held that pornography for minors is not protected. So how do you address that point?
Yes, Your Honor. While it may not be protected for minors, respondent may argue that adults still have free access to websites such as Pornhub. But in today's case, we can see that 80% of adults stated that they refused to access porn websites if they had to put in their ID for the risk of the sensitive information being leaked to the public. And this court has consistently recognized that content-based restrictions pose a heightened risk to free expression because they allow the government to favor or disfavor specific ideas or viewpoints. Reed v. Town of Gilbert determined that restrictions that discriminate based on the content of speech, including the ideas conveyed or the topics discussed, are inherently content-based.
Right.
The
So let me try a different way. I mean, we talk a lot about, Reeve Town and Gilbert. What about the Ginsburg case? How does the Ginsburg case affect this dispute?
Your Honor, Ginsburg was the case about an owner selling magazines to a minor, which in that case would be different. It differs from the internet where we cannot where companies and websites are not able to know for sure the audience that is able to access their content.
Right. So how does the law in Ginsburg differ from the Texas law?
Because, Your Honor, in Ginsburg, we can see that they strictly wanted to restrict minors from accessing pornography in the physical form of a brick and mortar store. But in today's case, because it's online and then they are being forced to put in their ID verification to a website of which they don't necessarily know where their information is going, it is limiting both minors and adults. And in
But let me just, I mean, you've never done this, but when you get older, you go to a store, you want to buy alcohol, you show your driver's license, right? You go to a casino, you want to gamble, you show your license, right, at the gate. How does showing your license to a clerk at a store or casino differ from submitting your age verification to the website?
Your Honor, it is different in submitting age verification on these websites because the when information is stored on the internet, it has the potential to be collected and possibly subjected to misuse, which discourages adult individuals from willing to conform to these age verification requirements, and thus creates a chilling effect on speech because these adult
But I mean, if the adults put their age information into the website, it's done, right? They submit it, they get the information. Why is that? Where's the chilling effect?
Your Honor, because they are being forced to enter their identification information from their legal ID and not necessarily, if it were simply just their age verification of clicking a box or checking that box, it would be completely different. However, in today's case, they were providing fragile information that they don't know where it necessarily is going. And if that information were to be leaked, I mean, I don't know a lot of adults that would like to be associated with pornography websites. So this creates a very damaging effect in today's case.
But just, Counselor, for a second, I'm looking at the text of the bill, and it imposes pretty heavy penalties for companies that store this information. It seems like Texas has done what it can to kind of straddle both interests of protecting privacy and also doing what's necessary to protect children from being exposed to this content. I guess my question is, in light of that provision, that there's penalties for a company who stores this, I'm still not really seeing a burden.
Your Honor, while the burden lies in that everyone is supposed to be conforming to the age verification and providing government issued IDs for verifying their age. But then while it does help to limit the types of people who are able to access the websites, such as minors, adults who are able to engage in the protected speech. They are the one being burdened by the First Amendment rights because they're not able to continue safely navigating the speech if they are if they knew the burden of having to of privacy concerns.
Also, Your Honor, we can see that companies themselves that are distributing pornography are being burdened by this law. We can see that Pornhub has already removed itself from states like Texas, and then we should look towards strict
Why
scrutiny.
did why did Pornhub remove itself? I mean, why couldn't they just comply with the law? They don't have to remove themselves. They can keep their content. They can just do age verification.
Your Honor, because Pornhub saw that it was going to be because it saw that it was going to be losing a majority of its users because of this age verification law, it decided that it needed to continue to go along with other states. Do you have any more questions for us, or may we conclude?
You can keep going. I'll give you 5 more minutes. It's fine.
Okay. Proceeding to the strict scrutiny applying to content-based restrictions, the First Amendment establishes that content-based laws must meet stringent requirements of strict scrutiny, which demand that a law must serve a government compelling interest and be narrowly tailored to achieve that interest using the least restrictive means.
The International Institute of Family and Life Advocates v. Vicarious, the court struck down a California law mandating certain disclosures from pregnancy centers, finding that imposing restrictions on a viewpoint or visual depiction is considered regulation on the basis of content. Similarly, HB 1181 targets content by requiring age verification methods and mandatory health warnings for specific types of speech and thereby regulating speech based on the nature of its content rather than the context that surrounds the distribution.
While
So
protect
another question of I'm still hung up on something that's a little bit different than what you're currently talking about. But you mentioned that for this test of it still needs to accomplish that purpose of here that purpose is to protect children from content, explicit content. I guess I'm not convinced that there are more narrowly tailored means of accomplishing that goal. I believe your brief mentions things like content filtering or things that parents can employ within the household. But I mean, just kind of looking at society at large, children tend to be more tech savvy than their parents. They're going to be able to find ways of getting around this whatever barriers parents might be able to impose. I guess I'm not convinced that the more narrowly tailored ways you might point to, they're actually accomplishing this goal.
Yes, Your Honor, and I understand where you're coming from, but as a teenager from the state of Texas, I know multiple peers who are currently using VPNs, other ways that they can navigate around the current ban of Pornhub in today's case. And so when we see that, yes, they are going to be more tech savvy. However, we can look at it from both sides of the coin. When we look at it in today's case, we can see that amicus briefs have stated how filtering systems have evolved and are a better system of protecting within the home, and that flips the burden of the state and the government towards parents being able to choose what they want their children being exposed to. And in Brown, the court rejected a similar age-based content restriction on video games, highlighting the availability of less restrictive measures to protect minors while preserving First Amendment rights.
As my co-counsel has said, we cannot really guarantee that the children are going to be that these verification requirements are going to really limit the children from being able to access the contents that they want to. They can always use VPNs and other methods of doing so.
Right, but the fact that you use a VPN to sort of work around these restrictions, that doesn't mean Texas is wrong, though. Why can't Texas choose to take a more of a precautionary method? In other words, if they want to simply say you can't access our content in the state, wouldn't that at least decrease some kids who might access? I mean, why isn't that enough?
Because, Your Honor, the material that is being judged for as harmful to minors does not only not account for differences in maturity or intellectual ability capable of minors. For instance, the content that may be deemed harmful to a young child may not be harmful for a teenager, yet HB 1181 applies a one-size-fits-all requirement standard. And this overreach chills speech that has legitimate value and could deter platforms from hosting constitutionally protected works, such as films, literature, or educational resources that address human anatomy and sexual health. When we look to the Miller test in today's case, we can see that the Miller test, as established in Miller v. California, sets up a three-pronged standard for determining what material is legally obscene and therefore unprotected by the First Amendment.
First, the average person applying contemporary community standards would find that the work is taken as a whole would would appeal to the Putin interest, and second, the work depicts the work depicts or describes in patently offensive ways sexual context specifically defined by the applicable state law, and thirdly, the work taken as a whole lacks serious literary, artistic, political, or scientific value.
And seeing as HB 1181 modifies this standard and broadens its scope to regulate sexual material harmful to minors, that includes content that may not meet the legal definition of obscurity under the Miller test. And it is for these reasons that we pray that the court overturn the lower court's decision and rule in favor of the petitioner. Thank you.
Very good. All right, thank you, counselor. That was fun. That was good. I'm sorry you don't have the experience of having opposing counsel. The schedule doesn't always work out, but that was a very good round. I'll tell you what I like. You're both very confident. You know the material well. You respond well to our questions. You're respectful. You give me yes or no answers, which I appreciate. I don't always get that. I got a lot of yes or no answers. And also, it looks like you're enjoying yourselves. I think you've come to a level of comfort with this area of the law that you're not looking, confused or flustered or losing focus. It was actually a very enjoyable round to judge, and I think that you both have come along. I've known you since you were early in your high school career, but you've come a long way and done a lot better. In terms of the substance, I think this is a hard case. I think you have these two lines of precedence. You have the Ginsburg case saying rational basis. You have ACLU saying strict scrutiny. And how to sort of reconcile these cases. It's not actually easy. It's actually a hard thing to do. I think both of you did it very well, and I commend you both. Thank you. Rob, any feedback you want to give?
No, just thought it was fantastic. Y'all were really, really well prepared.
Thank you.
Any
No,
questions?
we had a whole rebuttal prepared for a brief we read in case that you guys wanted us to actually rebut something.
Oh, that's okay. Well, I know it's not your fault, but the scheduling doesn't always work out. But I'm grateful that
Mhm.
you're able to do that. Very good. Anything else you want to ask us?
I think we're good.
Awesome, awesome, awesome. All right, I'll be in touch later this week. Thank you both so much.
Thank you.
Thank you.
Recording on.